Good morning, Professor Kavita. Good morning, Mansi.
Good morning,
and
sir.
all
Very good
students.
morning.
Good morning, sir. Good morning.
Yes. Yeah, yesterday's lecture, we have substantially dealt with the procedure as regard conducting of a trial. I'm sure all students were present, isn't it? Except Mansi. Mansi is a professor now. Okay. So
No, sir, no.
today we'll proceed a little further now. Of course, because the topic is substantially wide here. So we dealt with the provisions of Order 12, that is after the framing of the issues under Order 14, before the interlocutory stages such as discovery, inspection under Order 11, Rule 11, then filing of affidavit under Order 11, Rule 13, then submitting original document before the court, Order 13, Rule 1 and 2 CPC, then the court impounding the documents under the provisions of Order 13, Rule 3, 4. These all aspects, then the court passing orders under the Evidence Act as well as under the CPC. I mentioned to you, it is under section 135 and 136 of the Evidence Act. The trial judge passes an order whether to admit your document, admissibility and non-admissibility of document, and the question which is asked by the cross-examiner whether to accept it or not, objection can be raised. All these issues are dealt under both under the provisions of Order 13 as well as under section 135 and 136 of the Evidence Act. Okay, then we went ahead. Then Order 18 is the provision under the Code of Civil Procedure, which is invoked for filing your examination chief by way of affidavit now recently, which is being done. Whereas in criminal proceedings, you are not permitted to file affidavit unless the court permits on only formal evidence. That is how the procedure is. Secondly, the court can itself take up the matter for trial, for examination and cross-examination, or may appoint a commissioner. And normally the matter is entrusted to a commissioner after the framing of the issues and the court passing order with regard to the admissibility, non-admissibility of document. So the parties are told to give whether you're consenting document or not. That procedure is exercised under Order 12, Rule 1 and 2 CPC. You're seen, you give your admission of the document. And those documents you are not admitting, the court passes an order, then the counsel for the plaintiff or defendant who has produced the document, who starts the submission first, must argue before the court of law why this document is necessary, whether it's a public document falling within the mischief of under section 154 of the 174 of the Indian Evidence Act, or whether it's an admitted document under section 57, 58 of the Evidence Act, read with Order 12 of the Code of Civil Procedure. So there are parallel proceedings. Now, when the court is satisfied, because I told you that here, you are permitted to lead evidence either in the civil proceeding or in criminal proceeding, number one, in respect of matters which are in issue. The issues which are framed, the contentious issues, the disputed facts, the issues which the court has framed under the provisions of Order 14, namely, the issues are three types we discussed. Number one, the issue of fact, issue of law, and mixed question of law and facts, isn't it? These are the three types of issues. Only after exercising this procedure, then the court says that you are also permitted to lead evidence on it's not only fact in issue and the other facts which are other relevant facts. So the other relevant facts are not mentioned in CPC. The other relevant facts are mentioned from section 5 to section 55 of the Indian Evidence Act, which you have to carefully go through the Evidence Act at the time of the trial, without which you will not be in a position to conduct a proper trial. Okay, it is only after the court being satisfied with your argument as a lawyer for the plaintiff or defendant, then the court says yes. As I mentioned to you yesterday, you have filed a suit for declaration that the adoption is valid or invalid. Then you go and examine. You want to produce the school records where they may not be ceremony with regard to adoption. There may not be adoption date. It is not mandatory. So you fetch the school record where your father had admitted you, where your name is shown as the son, his name is there. So that's a relevant fact before the court of law. So similarly, in the case of possession, to prove that your possession is being disputed by the other side, you show that you are in possession for several years, for more than 15 years, 20 years. You may take up the plea that I have exercised my voting rights from this year. I received the election papers from here. You may submit the election record where your name is disclosed here. Election record papers, if you submit before the court of law, they become public document within the meaning of section 174. You need not examine the election commissioner. And you may say that I have also prepared a passport. A passport is also a public document that can be produced before the court of law. And if you rely upon electricity bill, rent receipts, or telephone bills, probably those are not public documents, except the fact that they are issued by those offices. The contents are required to be proved. You may have to examine the witnesses from there. So examination of the witnesses is also resorted to under the Code of Civil Procedure by invoking Order 16 of the Code of Civil Procedure. It's a substantive proceedings under Order 16 where an application is required to be made by you for examination of the witness, or the second procedure is also mere for production of the document. There are two types of exercises which can be conducted. If you want to record the evidence of an officer, then you can say that be pleased to issue witness summons to so and so office of the government, also of the municipality, for the purpose of producing the entire record relating to this premises, and also to depose before the court of law. Normally, public offices, you don't require them to give evidence. They had to merely produce the document. A rationing officer, you may say that the ration card is issued to you in your favor. The defendant will take up the plea that here the ration card is a bogus document, fabricated document. Then the onus is upon the person who relying upon the document and issue witness summons to the rationing office. And the rationing office may be pleased to issue the witness summon to the rationing office to produce the entire record, original record, with regard to the ration card number so and so. So mere production of the record itself is sufficient before the court of law. But the court has a right to ask various questions to any witness, which is very wide power under the provisions of section 165 and 166 of the Indian Evidence Act. Of course, parties also have a right to read it. So in case the witnesses to whom witness summons have been issued, they refuse to come before the court of law for reason A, B, C, D, the court has wide powers to take drastic action, such as issuing a warrant, attaching their properties, putting them in prison. Please note that a civil court has been invested with these powers, substantial powers in the matter. So the witness cannot say, I will not appear at the civil court. You have to appear. So this, you see the provisions of Order 16, Rule 8, 9, 10. These are the powers given to the court, even to a civil court or a revenue court or any court, any civil court can issue warrant compelling the attendance of a witness. They can issue a proclamation against the person who refuses to appear before the court. Yes, there is a bar under the law that here, a witness who is not residing within 500 kilometers, you cannot compel him unless there are means of travel, railway, or you may say that here air travel. You have to provide the charges for the same. Now, nowadays, with the advancement of technology, you can examine the witness on your videos and all that is permissible. Okay, this exercise, please, Order 16 must be carefully read along with the provisions of Order 18, which is a substantive provision for examination of the witnesses, read with the provisions of Indian Evidence Act. Okay, so after the examination, cross-examination, re-examination, which are dealt under section 137 of the Indian Evidence Act, then after you have a right to examine as many witnesses depending upon what are the issues. If there's an issue which has been framed with regard to whether the plaintiff has proved that the agreement is valid and subsisting, you should know whom to examine. Or whether the issue before the court that the will which has been executed is a valid document or not, genuineness of a will, then the provisions of Section 68 of the Evidence Act mandate that minimum one witness must be examined who is attesting witness. If you don't examine the attesting witness, you would not be in a position to prove the genuineness of a will. Similarly, mortgages, there's a mandatory requirement that you require two witnesses to sign the mortgages. If you don't sign, if the witnesses don't sign, the mortgage is an invalid document. That is a requirement under Section 58, 59, 60 of the Transfer of Property Act. You may see that here. So registration is also mandatory. So you must examine minimum one witness who has signed the mortgage deed. Otherwise, you will not be in a position to prove the mortgage document. As regard agreement of sales are concerned, witnesses are not mandatory. You may be aware. Many lawyers put also witnesses in the matter. The witnesses are not mandatory in proving an agreement. A vendor and the purchasers can be examined, or their representatives can examine before the court of law. There are issues with regard to res judicata. In the cases of res judicata, under Section 11 of the Code of Civil Procedure, the court frames a specific issue. Does the defendant prove that the present suit is not maintainable and hit by the doctrine of res judicata that is dealt under Section 11? For invoking res judicata, which is a doctrine which is analogous to doctrine of estoppel, and in the CRPC, it is analogous to the doctrine of a double jeopardy. You will learn under the CRPC Section 300. When the criminal court has tried and convicted a person or acquitted a person, he cannot be retried on the same charges again. That is the doctrine under the CRPC. Now, similarly, that is a doctrine based on the doctrine of estoppel and equity. Now, similarly, under the Code of Civil Procedure, one particular issue or a suit having been determined in a previously instituted suit between the same parties or the legal representatives, the same issue cannot be again re-agitated. Please note that here. So that issue is required to be framed. The onus will be upon the defendant to pay. I mentioned to you that under the provisions of Order 14, Rule 2 CPC, the issue of jurisdiction or any legal bar can be raised as a preliminary issue before the court. Preliminary issue means there may be 10 issues in the court. Issues of law dealing with your partnership right, dealing with your declaration, dealing your several rights under the law. But if it is covered by one particular issue like res judicata, or that the suit is not maintainable on the ground of limitation, or a previously suit was filed and withdrawn without the leave of the court, or that the suit, the remedy was available to a person which was not invoked at that time, hit by Order 2, Rule 2. These are legal bar. On the issue of legal bar, the estoppel and the maintainability, the court can dispose of the entire matter, deciding one issue itself. If the court has no jurisdiction, there is no point in trying the other matters and merits. So I mentioned to you yesterday that here, once the court comes to the conclusion that the court has no jurisdiction, territorial jurisdiction, lack of jurisdiction with regard to A, B, C, D matter, the court will return the plaint under the provisions of Order 7, Rule 10, with direction to the plaintiff to file the suit in a proper suit. But in the case of res judicata, the suit will be dismissed. The order will be, the suit stand dismissed, because the issue which is sought to be raised in the present suit is already covered in the previous suit. The defendant has produced before the court the judgment rendered between the same parties, or the judgment between the representatives, where the court has examined the witnesses and court come to the conclusion that here the suit is not maintainable for a reason, or the suit was decreed. The previous suit was decreed resulting in dismissal, or maybe being decreed awarding a decree in favor of the plaintiff. So second suit will not be maintained. The second suit, the court will pass an order, the suit stand dismissed in the wake of the fact that there is already a previous suit. Now similarly, Order 23 of this Code of Civil Procedure is very important for young lawyers and students to remember here. Under the provisions of Order 23, Rule 1 and 2, you have a right to withdraw your civil suit anytime you want it. Isn't it? But whereas in CRPC, you have no right to withdraw your complaint unless you have a right to compound the offense. Certain offenses are compoundable with the leave of the court. Sometimes some certain cannot. But so far as the civil case is concerned, the plaintiff can at any time withdraw the suit. Nobody can stop it. The defendant has no business to stop it, not even the court can dictate to him that don't stop it. At the most, what happens here, if the suit is withdrawn unconditionally, please note that, before commencement of the trial, before the decision of the suit unconditionally, a second suit would not lie on the same cause of action unless at the time of the withdrawal under Order 23, Rule 3, you had sought permission of the court. I may be allowed to withdraw the suit with liberty to file the suit in future on the same cause of action. Please note that. Anytime your client says that Mondoli ho chuki hai, hamari settlement ho gaya, client may be illiterate person. You just then thrown away. You have to protect his legal right. You make an application to the court, the parties are settling the matter, or about to settle the matter or settle the case, that your lordship be pleased to permit the plaintiff to withdraw the suit with liberty to file a similar suit on the same cause of action in future if need be. Normally, this liberty is granted by the court is not refused. But there is the other side has an objection, the court may hear it here. Sometimes you may file a suit here, the parties are negotiated for settlement. Settlement is not through here. So always apply for liberty. If liberty is not sought, please note that your suit is hit by, again, the doctrine of estoppel and res judicata here. Your suit may not be maintainable. So the court will frame the issue in that regard and the entire suit will go away, will be wiped out without going into the merits of the case in the matter. So these are the points at the time of the trial you must be very alert. And second, another important thing which I would like to tell young lawyers and young juniors students, then when you're conducting a trial on behalf of the plaintiff or defendant, when it is your turn to lead evidence, you have led evidence, namely examination chief ho gaya aapka, then your witness was cross-examined by the other side, then in the cross-examination, your client has made some mistakes. You have a right to do clarification of those mistakes. Get up and tell the court. Don't immediately say that the witness may be discharged. No. Your lordship may kindly grant me time to consider whether re-examination is required to be done. I have to go through the entire evidence. Make notes, and if there are mistakes, normally the court typewriter makes mistakes and the mistakes can be corrected. Request the court to keep the matter next day, tomorrow, or maybe afternoon session. Some time may be granted. Read the entire evidence. Cross-examination, while going on, you must be very alert. Take down each and every point. When your client has, because you cannot give any indication to your client how he can dispose before the court. An advocate cannot, he has to keep mum. At the most, advocate can only raise objection. For example, if a witness is being asked a particular question on the document which he is not the author, you may take up the plea there. My lord, this question cannot be asked to the author because the document speaks for itself and he is not the author. I am going to examine the author of the witness later on. If a document is 90-year-old document, a 30-year-old document under section 90 of the Evidence Act, the genuineness of a document is presumed. The other side cannot be probing into the document unless the document is written by your client. A document written by the witness can only be contradicted under the provisions of section 145 by putting him question. But if the document is not his document, though it's a relevant document, but he cannot be contradicted on this document. Please note that. Contradiction is permissible only in respect of the previous writing of the same witness who is before the court of law. Okay? Then if you find your client has made some mistake, some misunderstanding about the matter, he is not deposing correctly the way you are trained him, or the pleadings which are warranted, or he has been completely misled in the cross-examination, take time to the court that I will consider for re-examination. Now, re-examination is the court has to be liberal. The judgment of the Supreme Court is in this matter here. The re-examination must be liberal, and it is allowed for explaining the cross-examination, and also to lead some new evidence which may be necessary with the leave of the court. But normally you may not be permitted to fill up the lacunas which the clients have made. Suppose if he has made admission before the court, I have not paid any money. You cannot say tomorrow, yes, that statement is wrong. Some clarification can be given. For example, whether your father died intestate or testate. Your client may not understand this question. So he may take up the plea that whether any witnesses were present or not. Did you apply for probate or not? So you do not know, you are not trained him. I will have to check the record, that matter is being handled by another advocate. Then there are cases in respect of immovable property may come into picture. There must be a commotion in the locality. There's a breach of peace. There must be 145 proceeding, 146 under the CRPC. Under the 145, 146 CRPC, when there's a breach of peace, the person A will take up the plea that I was in possession, I was in joint possession, I have been dispossessed without due process of law. Then the magistrate, under 145, you have to file an application that there's a breach of peace with regard to water or with regard to the premises in the possession. The learned magistrate, 1 minute, somebody is asking me. Yes, can you hear me now? Yeah, the learned magistrate cannot pass any order with regard to possession of title of the property. The magistrate at the moot may come to the conclusion who was in possession. He will order investigation and inquiry by the police officer. If the inquiry is not satisfactory, the magistrate is not satisfied with the case of either party, he has a right to attach the property and seal the property. That sealing powers are passed under section 146. Now, at the same time, there must be a civil suit going on between the parties with regard to title or restoration of possession. Magistrate cannot decide who was in possession on the basis of the previous possession or on the who has a title, better title. That issue can only be agitated in a civil suit. So when you are leading evidence under the provisions of, say, for example, under section 6 of the Specific Relief Act, with regard to your disposition, and you are seeking order of reinstatement and order of mandatory injunction and mean profit, or a civil suit in the Bombay High Court or in the Small Causes Court, City Civil Court, for a declaration that you have been illegally dispossessed, you are a tenant of the premises, you are in the Small Causes Court, you seek declaration of tenancy in possession. In the Bombay High Court, you may take up the plea that I have been in occupation of the premises in my capacity as a irrevocable licensee or a joint purchaser or a whatever XYZ capacity, you have been dispossessed. So then you may be a mortgagee in possession, you have been dispossessed. So that may be an issue before the court of law, and your client has made contradictory statement before the magistrate under section 145, 146. Correlate the proceedings, both. Please note that here, under the provisions of the Indian Evidence Act, whatever statements your client has made before the magistrate can be taken as evidence, can be used in the civil proceeding, undertaking recourse to the provisions of section 33 of the Indian Evidence Act. So be careful in that regard. So see to it that here there is no, because as I told you that magistrate can only attach the property and keep the property under attachment, directing the, and also appoint a receiver. The magistrate will appoint a receiver of his court, maybe a police officer, maybe an advocate, maybe a subordinate magistrate, with a direction that the magistrate, the receiver appointed by the magistrate shall hold the property, keep the property under attachment till the parties' right title interests have been decided by a competent civil court, isn't it? So that may be City Civil Court, Bombay High Court, a Small Causes Court, or maybe cooperative court. That is how, then you have to correlate it. Then after the, suppose after your witnesses have been discharged, you completed the examination, cross-examination, re-examination, cover kiya. Then you tell the court, this witness I am discharging, I am closing my case subject to Hamisha, they is subject to availing a right of rebuttal. What is the right of rebuttal? Please note that tomorrow, if the defendant examines his witnesses and introduces some evidence which is fatal to you, which you did not anticipate at the time, you have a right to not only cross-examine the defendant witness, at the same time lead evidence of your own witness. Please, that provision you will find in the CPC Order 18, under Order 18, Rule 17, 16 and 17, permits you to lead evidence of a pertinence. Just open your Order 18. Mansi, open kijiye.
Yes, I have opened.
Order 18, Rule 17 was deleted. Thereafter, just see that relevant provision, power to immediately, yes. That provision is a Order 17. Court may recall and examine witnesses. Under Order 18, Rule 17, you have a right to recall witnesses. Now, this power you can introduce before the court of law after the defendant has led some fatal evidence against you. Evidence which is affecting your case, which you did not anticipate at the time when you examine your witness. Then you have a right to tell the court, you cross-examine the witness. I can, for example, the defendant has examined an architect or maybe a structural engineer to prove that the building condition is in a bad condition, not tenable, whatever reason may be. So evidence is led to show that here against your client has suppressed this point. So you cross-examine the witness, because the cross-examination of an expert witness is not an easy thing. Then you must take the leave of the court. I may be permitted to examine my structural engineer too in that regard. That issue was not framed by this court, but the client has led the other side. This honorable court be pleased to recast the issues. Issues can be recasted, can be amended at any stage till the judgment is given. That provision for recasting issues and amending issues, you will find Order 14, Rule 5 CPC. See, court to amend and strike out issues. Before passing a decree, kindly note that these powers are very vast. So you tell the court here, this honorable court has not been pleased to frame issue with regard to mean profits or issue with regard to the condition of the building. Other side has led the evidence because yes, maybe rightly so, because there are aberrations in that regard in the written statement, which now you do not have the opportunity to deny, because in the Bombay, the practice is that here, once a written statement is filed, you cannot file a rejoinder to written statement. Please note that. There is no rejoinder to written statement. The statement made in the written statement can only be denied at the time of the trial by your client plaintiff by leading evidence under the provisions of Order 18, Rule 4 CPC in the affidavit or examination chief. Examination chief may clause likhenge aap. The plaintiff, the starting of the case is that will be, I so and so the plaintiff do hereby state, solemnly affirm and state as under the present affidavit I am filing for the purpose as evidence under the provisions of Order 18, Rule 4 CPC for the relief sought in the claim. Then story starts. I say that so and so, I am the owner, I am the so and so property, defendant is a trespasser, he has no right title interest. I have exhibited the document showing my title XYZ. The defendant has no right in the matter. The defendant has to pay mean profit. The defendant has filed written statement raising false and frivolous pleas. क्या डालेंगे यहाँ पे? In the evidence, you must mention this. The defendant has filed his written statement raising false and frivolous pleas, and I refute the allegations contained therein. The defendant has falsely raised the plea that he has become a deemed tenant under the rent control legislation, or he has raised the plea that he has become a irrevocable licensee under the Easement Act, which contention I also raised. And he has taken up the plea that he has purchased the property from my father under the provisions of the section 54 of the Transfer of Property Act, and invoking section 54A, that is doctrine of part performance, which is also false and frivolous. ये डालेंगे आप, okay? ये डालेंगे, the contention raised in the written statement of false. I dispute the correctness thereof. This should contain in your examination in chief. Please note that. Don't try to miss it out. This is important. Okay. So, if there are no issues, you request your honorable court, the issue may kindly be amended in that regard. Taking recourse to the provisions of Order 14, Rule 5 CPC, you have a right to ask the court, certain issues are unnecessary, they may be struck down, or certain issues are not framed, which is relevant issue, that may be kindly be framed. And the defendant has led the evidence of the architect or structural engineer, which I have cross-examined, and I may be allowed to also examine though my case is closed, I would like to open my case. Under the provisions of Order 18, Rule 17, this honorable court has power to permit me to re-examine my witnesses. So, application will be. If there is no provision for examination, please note that you have to invoke section 151. See 151, the Kholiya Mansi, please. Section 151 is known as inherent powers of the court. Inherent powers are invoked as the last resort when there is no specific provision in the code for dealing with any situation. This provision is invoked by the parties, and the court exercises it in order to meet the ends of justice and to prevent the abuse of the process of the court. This is section 151, and also section 94, supplemental powers. Supplemental powers in the CPC, kindly open section 94. Section 94, supplemental power proceeding, supplemental proceeding. Section 94. Can you open this? Yeah. In the supplemental proceedings, in the last, you may say that here, 94E may make such other interlocutory orders as it may court may just and convenient. Here, the court can pass orders during the pendency of a suit, and under section 151, the court can pass orders, interlocutory orders, even after the passing of the decree. More wider. Now, section 151 is invoked by all the civil courts. There is no bar. That is city civil court, Bombay High Court, small causes court, and civil judge, junior division, senior division, district court, everybody. Now, in the CRPC also, criminal courts also have a power that is called inherent power under section 482. Just a little explain to you the two meaning between the two different. Section 482 CRPC open kijiye Mansi. Section 482. See the section 482, the provision is analogous to or akin to the provisions of section 151. So here, the inherent powers are given to only High Court. Kindly note that. The power of the High Court to make orders necessary for giving effect to under the court. Whereas in CPC, it doesn't say, it says the court. It doesn't say High Court. The magistrate, civil judge, the magistrates do not have power to exercise under 482. Nor the Court of Sessions can utilize this section under 482.
Sir, sorry to interrupt. So less than a minute is left. So meeting will
Anybody
finish.
has any question? Yeah, anybody has any question, you can ask me so far before anything. Any 1 minute. So I just want to convey to the students here, this topic is very important, inherent powers. When evidence is deficient, when there is no provision in the court, either in the CPC or CRPC, the courts are not helpless. The Code of Civil Procedure under 151, the court can resort to any power, and there is no power to implement an order passed by the court by giving a police officer to implement it. Under 151 of the IPC,